Investment advisory services offered through Global Financial Private Capital, LLC, an SEC-registered investment advisor. Global Financial Private Capital, LLC, and SWAN Capital are independent entities.
What your money would say. Andrew McNair. Money Talks. Are you listening? Money Talks. Are you listening? Money Talks. Are you listening? What your money would say with Andrew McNair.
We're live here on What Your Money Would Say. I'm your host, Andrew McNair.
And I'm your co-host, Scott Malleck.
And you're listening to What Your Money Would Say, where we take financial ugly ducklings and turn them into financial swans. But what does it mean to be a financial swan? It means to sleep well at night. And I believe as a retiree, you've worked your entire life to get to this point. See, you've put 3 kids through college. You saved money in your 401k plan and even found a way to put money to your charities and your local church. And it's time finally, when you reach the retirement age you've always dreamed of, to finally sleep well at night. And so we like to peel back the onion on topics that retirees worry about in every day. And so one of the topics that I feel like families worry about is titling of real estate and how to prepare for probate. So before we jump into that topic, I do want to share with you that our website just got a huge renovation. So check it out at swan-capital.com. That's swan-capital.com, and sign up for our weekly newsletter while you're there.
And my office is the law offices of Scott Malleck, and I believe in my practice in helping people to plan for something that most people do not like to talk about. And, with regards to
death and taxes is not a very fun topic.
That's exactly right. And most people are either afraid to talk about it or don't want to talk about it. And so it's really something that I want people to understand. It's extremely important to talk about. And so at my office, which is the law office of Scott Malleck, we really focus on creating an estate plan and hammering down the things that are necessary to create a proper estate plan. And if you want to visit my website as well, that's PensacolaElderAttorney.com. www, obviously, PensacolaElderAttorney.com.
And remember, this show is live, so you can call the station anytime with your questions about titling and real estate at 478-3116. That's 478-3116. So let's jump right into our topic, and let's talk about probate, Scott.
And in Florida, probate is the process. It's basically a specific area of the court system that deals with administering estates.
So it's not some mystical process. It's an actual court of law.
And yeah, that's exactly right. And there's a court system in Florida that's is specifically designed to deal with probate issues. And in Florida, there are 3 different types of probate. There's no administration, there's summary administration, and there's formal administration. And most of my clients that come in my doors are concerned with issues regarding formal administration. And if you qualify for formal administration, it means that you have over $75,000 in assets.
Which most of our clients do.
And that's exactly right. And, I mean, you've worked your whole life. The likelihood is that most people that come through my door that are trying to create an estate plan have over $75,000 in assets. And so formal administration, the reason that most of them are concerned about it is because in Florida, it can take anywhere from 6 months to a year.
Wow.
And
so that means those assets can't be dispersed to the heirs. So if I work 30 or 40 years and I pass away and I wanted to leave my legacy to my children, they have to wait 6 months up to a year sometimes before they can actually get my legacy.
And that's the average. So sometimes it can potentially take longer depending on variables such as will contests and things like that.
Right, if my kids get into it over it.
And, I see that happen. And unfortunately, I mean, it's a fact of life. That not everybody's always going to agree on everything, and it's part of the process.
You don't say.
Exactly. and so, that's the time aspect and the privacy aspect are another reason that my clients are concerned with probate, and that's because it is a public record because it is a court system. And in Florida, we have sunshine state laws that are basically open records, and the court systems, unless the judge specifically orders it, all records are open for the public to view.
And that's why you hear about celebrities like Michael Jackson and some of these large celebrities who went through probate and their dirty laundry spread out for everyone to see because it's a public process. And again, that can all be avoided if you try to minimize probate.
And that's exactly right. And another concern is obviously cost. And just to give you an example, I mean, attorneys up there in Tallahassee are the ones that are drafting your Florida statutes, and they've come up with, most politicians are attorneys.
Right.
And,
they come up with reasonable fees.
Exactly right. And they've come up with the reasonable fees that just the attorney can charge for an estate administration. And if you have anywhere between $0 and $100,000, they can charge you $3,000 for the estate administration.
$3,000.
If you have between that's the low end.
Right.
If you have between $100,000 and $1 million, they can charge you $3,000 plus 3% of whatever you have between the $100,000 and $1 million. So if you have $1 million in assets, an attorney can charge you a reasonable fee of about $30,000.
Wow.
Yeah. So minimizing the impact of probate is something that most of my clients are definitely interested in, because unfortunately, nobody wants to pay their people that are administering their estate such amounts of money.
And it's not like you have many other options. You know what they say about someone that tries to represent themselves in court, right?
And that's exactly right. Is if the old saying that a person that represents himself in court has a fool for a client. And that's exactly right, because you don't know the ins and outs of what the court's looking for, what the process requires. And so it's imperative that you have somebody that understands that process to help you guide your family through that process.
Sure. And so today's show is about real estate and how it correlates with probate. So many families' largest asset is their home or the property they own. And so what we hate to see is families, pay off their mortgage and feel very proud of it, and then unfortunately pass away hoping that they were going to leave their children their entire nest egg inside their house or their property, and then they have to pay, attorney's fees, court costs out of that, and their families don't get all those assets. So we're going to talk about ways that you can avoid that. And one of the ways you can do that is, first step is calling our office and scheduling a 1-hour estate planning preparation consultation. Basically, that's a 1-hour meeting, sitting down with me and Scott, making sure that all of your investments have been, the designations on those investments have been properly done and titled, and making sure that all of your real estate deeds are also up to code and up to date.
And with the new year coming around, it's a perfect time to look and see who your beneficiary designations are, what your deeds are, how your deeds are titled, and so on and so forth. And that's why we do offer the 1-hour free consultation, and we each individually offer it, and typically we do it
together. Yeah, which is nice because our offices are under one roof. So you can call our office at 380-5137. That's 380-5137. Now, remember, this show is live, and so if you want to call the station, feel free to do so, and we'll give you that number in just a few seconds. We'll give you some chance to get a pen. So let's talk about what are your options with titling. If you're looking at buying a house or selling a house, before you do that, you want to make sure that the deed's appropriate, but there's many options that can be on there.
There are many options, and there are several ways that I see that my clients, when they come through the doors, that they have their property titled. Some people, whether they're married or single, have it titled in a single owner. And so whether that's the husband or the wife, depending on their choice and the benefits that they are trying to accomplish, they may have titled their property only in their name. And
right.
That's a possibility, and that's a reason for people to do. There's reasons for people to do that, but it's not the only option out there.
Now, let's talk about the second one. Many times we have elder parents who want to put their children on their deeds. Can that be a good idea?
Well, I typically advise my clients not to do that. And the reason that is while it does seem easy and it does seem like it's going to help you avoid the real estate going through probate, because
sure.
Obviously if they're the owner,
it makes it a seamless transition.
But the problem with that is during your lifetime, if you live 20 years, those 20 years that you're alive, that you're joint owners, that property is subject to all the liabilities that your children may incur.
And that can be scary because, I don't know if anyone out there is listening. You might have a perfect family, but I know I don't, and I know many people don't have perfect families. So that can be a real issue because if you have a black sheep and a white sheep, your children on that deed, then you could have a lot of arguments. So again, the first two options on how real estate can be held is one, in your own name. Second, you can put your child's name on it, but there are some pitfalls of doing that. And then the next is what's called a life estate. Scott, will you share with us what a life estate is?
Well, a traditional life estate is when there's a person that has the right to receive the benefit of a property during their lifetime, and after they pass away, then there are future beneficiaries that will receive the benefit of that property after they pass away. And that's what a traditional life estate is. Now there are what are called ladybird deeds, which are essentially enhanced life estate in Florida, and it's really what the trend in Florida is starting to shift towards. Because what it does is, when I mean enhanced life estate, is the person that actually holds the life estate has the ability to transfer, sell, mortgage the property without any repercussions of what the future beneficiaries might think. And that's a difference between a traditional life estate, is that the current, in a traditional life estate, the person that is the life estate holder is accountable to the future beneficiaries.
Versus a ladybird deed, and here's a great example. If you're 80, 70 years old, and sometimes even into your 90s, and you're still own your own home, but you want to pass it on to your heirs, but you still want to live in it. You still want to have all the rights of ownership, basically, but you want to make sure that it bypasses probate. A ladybird deed can be a great tool to help you do that, because you don't have to answer to all your beneficiaries. You can make some of those decisions still on your own.
And it actually allows you to make all the decisions that you would have if it was a traditional deed, but as the life estate holder, and then it passes immediately upon your death.
Right.
And so what that means is, if you do transfer your property, or you do sell your property, or you do mortgage your property, then that ladybird deed is cut off, and it ceases to exist, and the actions that you took to cut off that deed are what supersede the future beneficiary.
And that could be fantastic for many families like you that are listening. So again, if you want to find out more information about ladybird deed and making sure that your real estate and your assets are titled properly, we do offer a 1-hour free consultation, what we call an estate planning preparation consultation. And you will sit down with me and Scott, and we'll go through your documents to make sure that everything's bulletproof for your estate plan. And you can do that by calling our office at 850-380-9558. That's 380-9558.
Or you can call my office at 850-403-0351. That's 850-403-0351. Or you can go on our websites. My website is www.pensacolaelderattorney.com, and that's Pensacolaelderattorney.com.
Yeah, that's pretty easy to remember. Yeah. That's a good one. I like that. That's catchy.
And you can actually request a consultation on there as well.
Perfect. And so, if you're just tuning in to What Your Money Would Say, you're listening to us talk about real estate. And I'm your host, Andrew McNair.
And I'm your co-host, Scott Malleck.
And we've been talking about the different forms of ownership. The next one I want to talk about is a joint survivorship.
Technically, it's called joint tenancy, but survivorship is a different aspect of tenancy. There are types of tenancy. What I mean by tenancy is, it's essentially co-owners of a property. So the most common type of joint ownership in Florida is in fact called a tenancy in common, or tenants in common. And what that means is that
so the most common is tenants in common.
Exactly.
That's pretty fun.
That's why it's the most common. But so say, for instance, Andrew and I owned a piece of property together, and we were tenants in common. What that means is that we each share, partial ownership, whether it be 50-50 or 66-33, but we have the ability to transfer, sell, mortgage our percentage of our ownership, and not without regard to what each other wants to do with the property. And and then the next type of tenancy is what's called a joint tenants with the right of survivorship. And what that means is that you own tenancy, and it has to be equal shares, it has to be created at the same time, and upon the death of one of the tenants, then the property will automatically pass to the surviving owner. And so that's what when we say survivorship, that's what we mean by that, is that property is passed between the owners after the one owner's death to the person that remains.
And you want to be careful, because if you think that, if I own it with the survivorship clause that my survivors would get it, you could be mistaken. So that would be huge.
And that's exactly right. Is if you own property as joint tenants with the right of survivorship, you cannot put that property in your will, because your will not be effective until that property has already passed to the survivor of that property. And that's one of the key distinctions also. Well, we're going to talk about tenancy by the entirety, which is the next one, which is a specific one that Florida has defined that is unique for married couples. And the reason that this is different from a traditional joint tenancy with the right of survivorship is because what it does is it provides extra protection from the co-owners getting rid of their ownership in the property. In a joint tenancy with the right of survivorship, if Andrew and I both owned it 50-50, during my lifetime, I can transfer, sell, mortgage my property, and it will cut off the survivorship and create a tenancy in common.
Right.
And I can do that without Andrew's permission. Now, if if
we're married, then
if my wife and I own property as tenancy by the entirety, I would have to have we would have to have spousal permission in order to convey, sell, mortgage that property, and that's the real added protection that a tenancy by the entirety
right
creates.
That you can get you have to get your spouse's permission. And that's huge for a lot of married couples because you will have that accountability. So we'll take a quick commercial break and we'll be right back.
Today's financial landscape can be rough. One of the most important aspects of planning is choosing the right guide to help you navigate the road to retirement. Andrew McNair and the team at SWAN Capital is dedicated to providing the very best service in the retirement planning industry today. SWAN Capital is a full-service independent wealth management firm dedicated to providing guaranteed custom income plans that you cannot outlive. Contact Andrew McNair at SWAN Capital 850-380-9558. That's 850-380-9558. The difference between SWAN Capital and you retire once. We help people retire every day. You should be enjoying your retirement years, not letting worry keep you up at night. SWAN Capital. Sleep well at night. Contact Andrew McNair at SWAN Capital 850-380-9558. That's 850-380-9558. Again, that's 850-380-9558.
The Veteran Benefit Project, founded by Andrew McNair, president of SWAN Capital, is a nonprofit organization dedicated to helping veterans and widows of veterans with long-term care expenses by qualifying for the VA's Aid and Attendance Benefit. Learn how to receive over $24,000 per year from the VA towards long-term health care. There is absolutely no fee associated with our assistance to the veteran, the widow of a veteran, their families, or any retirement community. Our goal is to preserve the dignity of the veteran and to reduce the dependency on the Medicaid system. Again, learn how to receive over $24,000 per year from the VA. Contact the Veteran Benefit Project 850-380-5137. That's 850-380-5137. 850-380-5137. Look us up on the web, myveteranbenefit.com. At the Veteran Benefit Project, we are committed to helping you secure the benefits you deserve.
We're live here on What Your Money Would Say. I'm your host, Andrew McNair.
And I'm your co-host, Scott Malleck.
And we're talking about real estate today and how that goes with probate and how you want to make sure that your estate is prepared for probate. So we have been talking about the different types of ownership with real estate. Let's jump into the last ownership, which is trust. So a trust can own your property.
Well, yeah, that's exactly right. A trust can own your property, and there are, as I mentioned with the caller, there are a variety of different trusts out there that accomplish different things. And typically what I deal with with my clients when we're talking about the types of trusts that are going to own property is revocable living trusts and irrevocable living trusts. And there are different benefits and drawbacks to placing property inside those trusts.
And some people get worried about revocable versus irrevocable, which one's worse, which one's better. And I want to tell you, it's just like in the financial world. There's no such thing as a bad investment. There's no such thing as a bad legal instrument. If there were, they would get rid of them. It's just based on your needs. When you ever hear someone complain about what they bought, it's many times because they didn't know what they were buying. They didn't talk to a professional who probably truly understood it and didn't explain it right. So let's talk about transferring ownership to a revocable trust first.
So when you transfer ownership to a revocable trust, there are lots of things, because most people are concerned about tax issues and homestead exemptions in Florida, and that's one thing that the courts have determined is that if you transfer your property to a revocable living trust, you can maintain your homestead exemption. And what that means is that because a revocable living trust, the person that's granting that trust, creating that trust, retains so much control over
It's still
it.
the trustee. It's basically their alter ego.
Essentially, exactly. It's our alter ego. So basically, because they have so much control over it, the court has determined that they can maintain their homestead exemption. Now, we had a client come in the other day, and unfortunately, they had an irrevocable trust, and
Which the irrevocable trust was great for their cash assets and their investments, but you sometimes don't want to mix that with real estate, and so that's why you got to be very careful. See, my grandfather, unfortunately, when he passed this year, he passed with two kinds of trusts. He passed with an irrevocable trust and also a revocable trust, one for the property, one for the cash assets, and that allowed him to continue keeping the homestead exemption. It allowed him to keep ownership and transfer the cost basis, and I'm going to talk more in detail about that. But also, his other assets immediately were protected from VA planning, and it started the 5-year look-back period for Medicaid. So that's why it's great to actually sometimes own more than one trust.
And, that's exactly right. And the problem that I was kind of alluding to was the difference between a revocable and irrevocable living trust is the reason that the courts have distinguished that with regards to homestead exemptions, and we're talking about real estate here, and most people are concerned about maximizing their tax deductions and
Sure,
and paying as little as they can to the government. I mean, nobody
Absolutely.
wants to pay a huge tax bill.
I work till Wednesday for him.
Exactly. And so basically, in an irrevocable trust, the way the court has determined that is because you don't have any control over that, the assets that are in that trust. If you place your home that is currently your homestead exemption into that trust as the owner, you lose your homestead exemption. And so as I kind of mentioned, we had a client that came in the other day that mentioned that they had already transferred their property into the irrevocable trust that we had created for them, and they did that without consulting us. And unfortunately, the cost basis, and I mean I know Andrew's going to talk about the cost basis and all that, and that's his area of expertise. And so tell us a little bit about the cost basis.
Yeah, it can when you're making big decisions like transferring property, that is again a big decision. So if you make the mistake of just not consulting your estate planning attorney like Scott, or not consulting your wealth manager like me, then you can fall prey to making some very they're just honest mistakes, but they can cost you a lot. So let me give you an example. If I had a $100,000 home and I want to bypass probate, because probate's going to be about $3,000 on that. So I want to avoid $3,000 of probate costs. So if I move that thinking that it's a good idea to an irrevocable trust or to a child, my cost basis does not go to that child, and it doesn't go to an irrevocable trust. Now, it will with a living trust or a revocable trust, but it won't. So here's an example. So yes, you would save the $3,000 in probate, but if you bought the home for $50,000 and you have a cost basis of $50,000, right? Because you bought for $50,000, but you still owe, you still made $50,000. That's what we call a capital gain. So that would be a $50,000 capital gain. Well, if capital gains tax is, let's say, 15%, then at 15%, you're going to pay $6,000 plus $7,000 on capital gains tax. So do you want to, save $3,000 and pay $7,500? That doesn't sound like a great financial decision, but people are making these decisions every day and paying the consequences because they're trying to do it themselves.
And that's exactly right. And it's not that that our clients are unintelligent. It's just that they don't know that there are consequences to certain actions that they take.
Sure, you don't know what you don't know.
Exactly, and that's why we always tell our clients, and I communicate with my clients. I try to within a few hours of them contacting me, and one of the biggest complaints with the Florida bar with attorneys is attorney-client communication, that attorneys never talk to their clients.
Right, because they sold a trust and, hey, they made their money and send you out the door.
But, it's not an autopilot thing.
No.
Planning an estate is, we always say, life happens and things change. And
you got to change with it.
Exactly. And so, if things come up that need to be done, we always encourage our clients to give our office a call, because I don't mind, something I could tell you in 5 minutes that's going to save you,
$7,000. That's a huge benefit. And I want to encourage you, if you're thinking about some large financial decisions or estate planning decisions, use this as a sounding board. Many people come in for our free hour consultation because they're, just sold property or they're about to sell property, and they want to make sure that everything is done properly. So we're going to give you an opportunity to reach out to us, and that is for our 1 hour estate planning preparation consultation. And so you can call our office at 380-9558. That's 380-9558, and our office will get you scheduled to see the both of us. If you just want to ask your question live on the air, remember this show is live. You can call in with your questions regarding retirement planning or estate planning at any time. And so let me give you that number. If you're driving, don't wreck, we'll go give it to you slowly. The number is 478-3116. That's 478-3116. And we'll be happy to answer your question live on the air. So let's talk about, if you have an elder parent or you're getting elderly yourself and you're looking at moving into an assisted living or a skilled nursing facility, did you know about your homeowner's insurance and how that will be affected? I have many clients that come to me and they said, hey, we moved mom or dad in to assisted living. He's been there for 2 months. And then I start asking, well, who's living in the house? Well, no one. And so that becomes a huge issue, because if, a fire happens at the house, who's going to put it out if no one's living there? So this is why insurance companies are raising their prices on families that are not living at that property, or they won't cover you if an incident happens. So that's why it's important to call your insurance, your homeowners or auto insurance carriers, to make sure they're aware of that change, or sell the property pretty quickly.
And that's the other thing too, is if you aren't maintaining, or nobody in your family is maintaining that as their permanent residence for an extended period of time, you can actually lose your homestead exemption as well.
Right.
And most people don't know that, is they think that, well, this is the only property I own and this is what, is my house, so I'm going to have the homestead exemption. Is, in Florida, if you're not living there and maintaining it as your primary residence, you can lose your homestead exemption.
The other mistake I see families make with real estate is they'll have, 3 children, and they want to make sure that their children get it evenly, but they want to make sure they bypass probate. So what do? They start sticking their children's names on their property. Scott, why is that a terrible idea?
I don't know how many people have walked through our doors that have said, oh, my parents and I have our names on their checking account. And it boggles my mind. I understand.
No, I literally, this is yesterday. I had someone have over $500,000 in CDs and checking accounts that their children were on.
And that's exactly right. I can't stress it enough. If you do that, you're subjecting your accounts to your children's liabilities. And what that means is, if they are the owner, or their name is on it as a joint owner, essentially what you're saying is that this is partially their property.
Right.
So if they get into a lawsuit for a car accident, or they go through bankruptcy, and
someone slips on their property.
Exactly. Those are all things that can create liabilities, that can have creditors attached. And what they will do is they'll receive a judgment and they will attach all of your children's properties. And what that means is that those creditors, or those people that have received those judgments, can now have access to your property as a result of your children's actions.
And this might give you another thing to chew on. How many of you would just trust your son-in-law, your daughter-in-law with all your money? Not many, right? And so many people are doing exactly like doing that when they stick their children's names on their accounts. Basically, you're saying, I trust my son-in-law and daughter-in-law. And then when I ask families, do they truly trust them that much? They're like, no, I never knew that, because, they've had marital problems for the last 10 years and it's on rocky shore. So you want to make sure that you're not, putting your legacy in the hands of potential creditors and people that are just trying to, chase ambulances.
And the reality with that is that it's a really easy fix. I mean, if you put a power of attorney in place to deal with your financial matters or your healthcare matters, I mean, it's a really easy fix, and that is what should be done so that the people that may have liabilities and children that have liabilities and creditors don't have to deal. They have that added protection. And so
Sure.
I always advise my clients, instead of putting yourself as a joint owner, make sure that you have a power of attorney in place so that your children can act if they need to, but they don't have that they're not subjected to that liabilities.
And it's never too young. Even I, in my late 20s, have a power of attorney because I think it's important, because you never know when illness or health strikes.
That's exactly. I mean, I keep saying that's exactly right. And the more he says it, the more it doesn't change the fact that it is exactly right. I could drive out onto out of the radio station today, and I could be hit by a car, and I don't know that's going to happen. And what happens when my wife, if I don't have a power of attorney, my wife's not my power of attorney, what happens when I need her to make all those decisions?
While you're in the hospital, you need to pay bills.
Exactly.
So that's why it's important to have a power of attorney.
Exactly.
The other thing that I see mistakes happen is many of our clients are very successful, so they own property in multiple different states. Being on the Alabama line and Florida line, you can have many families that own property in Alabama, Louisiana, Mississippi very easily. So tell us how that could be a nightmare.
Well, it's not necessarily a nightmare, but because clients that own property in multiple states, it just means that they're typically doing well financially. If you have multiple properties, it's because you know what you're doing. But the problem that they don't think about is that typically property is governed by the laws of the state where the property is. And so if you have a house in Alabama and a house in Florida, you could be potentially subjecting yourself to probate in both Alabama and in Florida. And that's not because they want to make it difficult for you or anything like that. It's just that that's the way that the laws are set up. And so when I have clients that come in that have these issues, that have property in multiple states, that's typically when we say, you might be a good candidate for a trust. Because what a trust will do is create a legal title holder for makes the trust the legal title holder for those properties, and then the trustee is allowed to administer those properties per your instructions. And they don't necessarily have to go through each individual probate.
And if you want to find out more about how you can do that for your property in multiple different states, please give us a call at our office. That's 380-9558. That's 380-9558 to schedule your 1 hour free consultation to make sure that your estate plan is properly protected.
You can also give my office a call at 403-0351. Again, that's 403-0351.
All right, we'll see you right after a commercial break.
Today's financial landscape can be rough. One of the most important aspects of planning is choosing the right guide to help you navigate the road to retirement. Andrew McNair and the team at SWAN Capital is dedicated to providing the very best service in the retirement planning industry today. SWAN Capital is a full-service independent wealth management firm dedicated to providing guaranteed custom income plans that you cannot outlive. Contact Andrew McNair at SWAN Capital 850-380-9558. That's 850-380-9558. The difference between SWAN Capital and you retire once. We help people retire every day. You should be enjoying your retirement years, not letting worry keep you up at night. SWAN Capital. Sleep well at night. Contact Andrew McNair at SWAN Capital 850-380-9558. That's 850-380-9558. Again, that's 850-380-9558.
The Veteran Benefit Project, founded by Andrew McNair, president of SWAN Capital, is a nonprofit organization dedicated to helping veterans and widows of veterans with long-term care expenses by qualifying for the VA's Aid and Attendance Benefit. Learn how to receive over $24,000 per year from the VA towards long-term health care. There is absolutely no fee associated with our assistance to the veteran, the widow of a veteran, their families, or any retirement community. Our goal is to preserve the dignity of the veteran and to reduce the dependency on the Medicaid system. Again, learn how to receive over $24,000 per year from the VA. Contact the Veteran Benefit Project 850 850-380-5137. That's 850-380-5137. 850-380-5137. Look us up on the web, myveteranbenefit.com. At the Veteran Benefit Project, we are committed to helping you secure the benefits you deserve.
We're live here on What Your Money Would Say. I'm your host, Andrew McNair.
And I'm your co-host, Scott Malleck.
And we're talking about real estate and how it affects probate. And one of the questions I commonly get when it talks about, hey, should I put my child on my property? I want to make sure that I bypass probate as much as I can. People start talking about gifting. And so there's many misconceptions about gifting. And again, we always bring in a tax professional, just like you should when making tax decisions. But people need to understand the basics of gift taxes. So
what is a gift tax exclusion?
Good, that's a good question. So the gift tax exclusion over a lifetime is $5.25 million. So what does that mean? Basically, if I give you, who's a friend of mine, $10,000, do you have to pay taxes or do I have to pay taxes? Well, no one has to pay taxes, actually, and I don't even have to tell anybody. It could just be between me and you, because every year there's a $14,000 exclusion, annual exclusion per person. So if I give you $13,999, still the same thing. You don't have to report it, and neither do I. But when you give over $14,000, and that increases every year, $14,000, that is the point where you have to report it to the IRS. Then all my clients start asking, well, now do I start have to pay taxes? That's not the case either. $14,000 just means that they have to deduct it from your lifetime exclusion. So I could easily give you $200,000, and if I haven't used my lifetime exclusion, then you don't have to pay taxes, and neither do I.
So essentially what you're saying to me is that with the lifetime exclusion being $5.25 million, if somebody, say my parents gave me $264,000, essentially, which is $250,000 over the annual limit,
mm-hmm.
I would have my lifetime limit would be reduced from 5.25 to $5 million.
Yes, they're going to reduce it.
Okay, perfect.
Yeah, so it's very complex when it comes to gift taxes, and I think sometimes we make it sound a little bit more complex than it is, because many families could use gifting when it comes to charitable giving, and they could also use it with legacy planning. So if you're worried about how do I avoid gift taxes and avoid not having all my assets go through probate, that's why we encourage you to schedule that 1-hour estate planning consultation.
Now, is there a difference between a gift tax exclusion and an estate tax exclusion?
There is. I mean, there are the same, the $5.25 million. Now, there are strategies that we help clients with, me and Scott, where you can actually double that exclusion, so you can get up to $10 million. And many of our clients that have those assets want to make sure that they don't pay a death tax, that can be very high on money that's already been taxed, right?
Yeah, that's correct. And I mean, we really try our best to make sure that, why we believe in total wealth management is to try to make sure that all the pieces are in place in order for you to maximize your estate. And in order to ensure that if there are tax benefits or tax exclusions that you may be missing out on, that we make sure that you are informed about those and we help you steer you towards that direction.
And I'm glad you brought up total wealth management, what we call TWM. Total wealth management is what we believe is just common sense financial and estate planning. But it seems like the world hasn't caught on yet. When I started in the industry at 14 years old. I even at that age, I knew that there was something wrong. Families would come into our office when I was interning at a financial firm, and then they would get financial advice. Then they would walk outside, go to an attorney, get their trust done, their wills done, and then they would leave there, and on April 15th, they would go see their CPA. And what's really interesting, and most people say, is this really true? Those professionals never talk to each other. Sometimes they don't even know each other, let alone talk about that client's individual needs and goals to make sure that they work seamlessly and synergistically together. And that's what we do at Total Wealth Management.
And I love football, and I love football analogies. So, I mean, for me, do you want a head coach that doesn't ever have all of his pieces in place, his special teams coordinator, his defensive coordinator, his offensive coordinator? the way that you have a winning team is those people are working together in order to create the best play call for their respective teams. And that's why we have that philosophy of total wealth
That's a great analogy, because you're the head coach of your financial future, and many of our clients are what we call in the retirement red zone. They're 5 yards from being in retirement, or 5 yards from making tough long-term care decisions, and they can't throw a Hail Mary, and they can't make a mistake by punting the ball. They have to make sure they do solid conservative strategies to make sure they indeed have the retirement they've always wanted. So let's talk about the ways you can own real estate. And if you're just tuning into What Your Money Would Say, we are talking about real estate ownership and how it affects probate. So let's talk about the options. The first one is,
well, the most often, not necessarily most often, but there are some times when clients walk into my office and they have property that they own solely, and typically there are no issues regarding liabilities and the other kinds of problems that can come up with different types of titling when you own as a sole owner.
Yeah, because if you pass away without a will, that could be a problem, right?
That's true. And if you don't have a will, Florida has one for you, basically. I hate to say it, but
I didn't write that though, so some bureaucrats must have wrote that for me.
If you've ever been to a football game or camp when you were younger, and they gave you those one size fits all shirts,
it's not very flattering.
It's not. It's not tailored specifically to your body. It's not one of those well-tailored tuxedos or a very nice tailored dress.
Yeah, it's huge. It's like a ship's mast.
Exactly, and that's really what Florida statute does. Is it's basically a one-size-fits-all will. And
right.
If you die, because unfortunately there are people that pass away in Florida that don't have a will, and something has to be done with their estate. And if you don't have a will, I know we're kind of getting off talking about wills here, but if you title it in your own name and you don't have a will, you don't have the choice of who it goes to. So your property is going to pass based on how Florida statutes has defined it.
And some people may have some questions about that. And remember, this show is live. If you want to call the station with your estate planning or retirement planning question, don't hesitate. Change your name if you want to, keep your, stuff confidential. Call us at 478-3116. That's 478-3116.
And if you feel nervous, you don't want to talk on the radio, live on the radio, you can always give our office a call as well. My office number is 403-0351, 403-0351, and Andrew's number is
at 380-9558. That's 380-9558.
And we'd be more than happy to have a conversation with you, set up a consultation, and discuss with you the issues that you may have in your estate.
Right, and they say it's impossible to get a second opinion from the person that gave you your first. So that's why we encourage you to give us a phone call. And so the second way you can own property is placing your children's name on it. Is that a great idea?
I hate to say it, but I laugh when people, it's not that I'm laughing at them, it's just there's so much misconception about placing your property in your and your child's name. I understand that it makes it easier, and it helps facilitate and get around probate.
Yeah, and many families are just like, hey, they're staying here. They come out on Thanksgiving. It's going to be theirs anyway. I might as well just put that property in their name.
And that's typically what I hear from my clients. And the problem with that is that they don't think about the liabilities that their children make. Their children are driving around on a daily basis. We typically deal with elderly clients, and they may not be going out and driving around every day, going to work every day, doing all those things that
doing life
exactly
on a regular basis.
And so, your children are out there. They may get hit by a car. They may run into somebody, or
someone may slip on the asphalt while they're watering their grass.
Exactly. They may own a business, and they
have liabilities.
Exactly.
The business could go under, and they could get a divorce, and all those things will affect the property that, again, you've worked 30 years to pay off.
And our clients, it's not on the forefront of their mind, because everybody wants to think that their child is perfect. I understand that. And
their child's not perfect. There's no perfect families out there, Scott.
Mine's not perfect.
I know mine's not either.
So they don't think about the fact that their child may unfortunately be driving up credit card debt, and then if they're on their checking account or
and
their
the creditors
property,
come after them,
their creditors come after them, their property may be subject to that their children's creditor.
So you want to be very careful if you put a child's name on the property. The other way is a life estate, and we're going to focus more on the ladybirds. There's traditional life estates, but there's also ladybirds.
And Andrew mentioned that, and there's a difference between traditional and ladybird deeds. And what a ladybird deed essentially is an enhanced life estate, and it's really the kind of the way that the trend is moving in Florida today. Is what it does is it allows for a husband and wife or somebody that owns property to place a deed or put a deed in place that allows them to transfer still, to sell their house or their property, to mortgage their property, basically do whatever they want with their property.
Have all the rights of an owner.
Exactly. You have all the rights of an owner, but you only have a life estate. So as soon as, if it's still in your possession upon your death, it passes to the person that's named in the ladybird deed. But if during your lifetime you choose to sell it or you choose to transfer it, it cuts that beneficiary short, and the person that you've transferred it to is now
so you're not stuck in that house when you do that ladybird deed.
Exactly, and that's really the
great
difference between a ladybird deed and a traditional life estate is that in a traditional life estate deed, the life estate holder was accountable to the future beneficiary.
Right, and who wants to have to ask permission from their children all the time? That can be frustrating.
Yeah, that's true.
The other one is joint tenancy, and there's multiple different variations of joint tenancy. I'm looking at buying another investment property just recently, and we're partnering with another young man, and he was talking about, hey, how do we title this property? And so if Scott, you'll tell us a little bit about the variations of those.
There are several different variations in Florida, and they basically accomplish different goals. And it's we keep going back to we want to talk to our clients about what they're really trying to accomplish with their life or with their estate plan, and so that can come into play when determining how to title your property, whether it be a tenancy in common, a joint tenancy with right of survivorship, or a tenancy by the entirety. What a tenancy in common is basically you are a co-owner with another person, and you have equal rights as that person in the property. You may have equal shares, you may not, regardless of how many shares you have. So if I have 33% and Andrew has 66%, I still have the ability to use and to benefit from that property. And I also have the ability to transfer, sell, mortgage my percentage of the property. Basically, when I pass away, if we own it as tenants in common, I'm allowed to transfer it by will, which is a distinction between the next two types of tenancy. So a joint tenancy with the right of survivorship means that
it's the opposite.
It's not necessarily the opposite, but what it does is it creates an extra layer of passing the property.
Okay.
So what that means
Glad you clarified that for everybody.
Yeah. So what that means is that if Andrew and I owned as joint tenants with right of survivorship, a home or a piece of property, that during my lifetime I can still transfer, convey, mortgage, or sell the property. What that means is that if I do that during my lifetime, it would convert the property into a tenancy in common. If I don't do it neither of us do it during our lifetime, and one of us passes away, that right of survivorship, so if I passed away, Andrew would automatically become the 100% sole owner of the property, and there would be no probate issue.
And it wouldn't pass to whoever I designate my will.
Exactly. And so if I passed away, my will would not control that property because it passes the second that I passed away. So that's the difference between the tenancy in common and the right of survivorship. And the last one is a tenancy by the entirety. And what that is a joint tenancy with the right of survivorship, but for married couples. And the reason that Florida has defined one for married couples is because they wanted to create an extra layer of protection. As I mentioned, during my lifetime in a joint tenancy, that if Andrew and I owned as joint tenants, I could sell my property or transfer my property or mortgage my property. In the tenancy by the entirety, you have to have both spousal permission in order to.
You're saying that they had to add that because people didn't consult their spouse?
That's exactly right.
Some people don't consult their spouse on things.
In order for, there was some issues, and Florida decided that they wanted to create, and unfortunately, it was usually husbands taking advantage of their wives.
Oh, men don't make all those mistakes.
So if there was going to be a divorce or something, and so Florida statutes, the Florida legislature decided that they wanted to create extra protections in a tenancy by the entirety. And so what that means is that both spouses have to agree upon the transfer, sale, or mortgage of a property.
The other way of owning property is through the use of trusts. And there's many different flavors of trust. You know, it's basically like an ice cream parlor. They all have different flavors and they all have different objectives. That's why you have to meet with someone like Scott and I to make sure that they work financially and estate planning wise, that you pick the right kind of trust. But I'm going to break it down to two basic categories just for simplicity's sake. There's revocable and irrevocable. So if you place your assets into a revocable trust, that can sometimes be like an alter ego of yourself. And so that's a great way where you can actually bypass probate, but still keep homestead exemption and still keep your cost basis of when you bought the home.
And I mean, they're kind of aptly named. I mean, when you have a revocable living trust, it means that you have the ability to, if you don't want the trust anymore, to cancel it. And that's the difference between a revocable. I mean, you can revoke it essentially.
Right.
And the difference between a revocable and an irrevocable is the person that created the trust in an irrevocable trust cannot actually cancel the trust.
Gotcha. And with an irrevocable, if you make that mistake of transferring ownership to an irrevocable trust and you're trying to avoid probate, you can actually lose money, because if you didn't take in consideration the capital gains tax, what you call your cost basis, you could pay actually way more than you would have in probate. So you got to be very careful. Just like if you transfer ownership to a child's name, we didn't really talk about that. You could lose your cost basis in that house. So if you, many people do this. Many of my clients bought their home for $30,000, and now it's worth $150,000. Well, that's a huge capital gains that you would have to pay 15% on. So before you make any rush decisions about real estate, I encourage you to give our offices a call, because again, like we talked about, total wealth management is the philosophy that two minds are better than one, and that we can sit down and look at your financial plan and your estate plan and make sure that we find that money is not falling through the cracks. And so you can call our office at 380-9558. That's 380-9558. And we'll see you next time on What Your Money Would Say.